Hello everyone, this is Devanshi Masand and I along with my colleague Kaustubh Kulkarni will be dealing with the topic of Incorporation of Company throughout this video. So before moving ahead with incorporation, I would just like to introduce you to some basic concepts of company law. So firstly, what is a company? A company is a legal entity incorporated under the Companies Act 2013 or any other previous company laws. It is formed to achieve a common object which is defined in its memorandum and to conduct business. Now we'll discuss some basic types of company. So firstly, we'll discuss types of company based on ownership of the company. So the first type under this is a public company. A public company is a company owned by the public, that is owned by the stockholders who are members of the general public and the shares are traded publicly. To form this type of company, there is a requirement of at least 7 or more people. Second type is private company, where the ownership is not traded publicly, that is where the company restricts the right to transfer its shares. Now to form this type of company, there is a requirement of 2 or more people at least. The third type is one person company. Now as the name suggests, the company only has one member and it forms generally, it is a subtype of a private company only. Now what are the types? Based on liability of the members. So the first type is when the liability is limited by shares. In this type, where the liability of the members is limited by the memorandum to the amount unpaid on the shares respectively held by them. In the second type, the liability is limited by guarantee. Here, the liability is limited by the memorandum to such amount as the members have respectively undertaken to contribute to the assets of the company in case it is wound up. The third type is unlimited company. Here there is no limit on the liability of the members of the company. Now this is a very rare scenario and the members of the company only choose this model because the profit sharing therein is huge. This type of company is very close to the form of partnership. Now that we have dealt with the basic concepts, we'll move on to the main topic of the video. So what is incorporation? So there are 4 steps of a formation of company. The first is promotion. In this step, the idea of the starting of business is realized and steps are taken by the promoters. Who are promoters? They are the ones who have conceived the idea. So steps are taken by the promoters required for bringing the enterprise into existence. So basically what all is included here: finding investors, scoping out land, etc. Now incorporation, that is there, is the second stage of formation of a company. Now here in this stage, the company actually comes into existence. Now how does the process of incorporation go? The process of incorporation is mainly covered under section 7 of the Companies Act 2013. So what is the first step here? The first step in incorporation process is reserving the name of the company with the registrar of companies by making an application along with the prescribed fees. Now what does the registrar do? He reserves the name for 60 days after receiving the application. Now what can the name be? Anything. What it should not be is similar to the name of an existing company or be such that its use will either constitute an offence under any other law for the time being in force or is undesirable in the opinion of the Government of India. Or it should also not contain any word or expression giving the impression that it is linked to the government in any manner. Or it should not contain such word or expression which may be prescribed by the government to not use without its previous approval. Now, the name is reserved for 60 days. So what do you do after reserving the name? You submit all the necessary documents with the registrar. What are these documents? So first is the Memorandum of Association. What is the memorandum? Memorandum of Association contains mainly 5 clauses. This document basically constitutes the company. First is name clause, wherein obviously the name of the company goes. The registered office clause, the objects clause. In this clause, the object for which the company is being incorporated and anything necessary in the furtherance thereof is written down. Then there is the liability clause, whether liabilities by shares, by guarantees or unlimited liability, that way. Then there is capital clause. Herein, the amount of share capital with which the company is to be registered and its division into shares of a fixed amount is given down, and the number of shares which the subscribers of the MOA agree to subscribe. In case of one person company, the name of the successor of the company should also be provided in the memorandum. Now the second document is Articles of Association. Now this is basically a document that states the rules which the internal management of the company will follow. It creates a contract between the company and its members. Now Articles of Association may also contain provisions for entrenchment, that is fortifying certain provisions to the effect that they may be altered only if certain condition is fulfilled or a certain procedure is followed. Such entrenchment can only be made either at the time of the formation of the company or by an amendment which should be agreed upon by full majority in a private company, and in case of a public company it is done by special resolution. If such entrenchment provisions are added in the Articles of Association, a notice is to be given to the Registrar of Companies informing the same. Now, while submitting memorandum and Articles of Association, both have to be signed by all the members and subscribers to the MOA in the prescribed format. The third document is a statutory declaration. This is a declaration either by an advocate or a chartered accountant or company secretary or a cost accountant who are involved in the formation of the company, and by either a director, manager or secretary of the company, that all the requirements under the Act have been complied with. Now for this, there should be affidavits from the subscribers and directors stating that they have not been convicted or found guilty of any offence relating to Companies Act, and that the information provided to the registrar is true to the extent of their knowledge. The address for correspondence until the registration is complete, and the particulars of all the subscribers and directors is also to be provided to the registrar. Now there should also be affidavits stating the consent of the directors, accepting the position of a director, and consent to perform the required acts as a director. And lastly, there should also be a power of authority, which is authority given to the attorney to carry out the necessary functions like making changes in the memorandum or Articles of Association as required by the registrar. Now, after submitting all this to the Registrar of Companies, he scrutinizes it, and on the basis of the documents and the information filed and submitted to him, he registers all these documents and information and issues a certificate of incorporation. He also lots a corporate identity number, which is basically the identity like an Aadhaar card for the company. So from that date, the company becomes its own legal entity and the concept of corporate veil slips in. So what happens, the liability that was there on the promoters till now, that is the owners of the company, now falls on the company as it has become an own legal entity. It becomes a body corporate and it can sue and be sued in its own name, and it can also hold property in its own name. So after what is the effect of incorporation or registration? Now there are three kinds of liabilities of the company. First is contractual liability. Now, what is contractual liability before the incorporation of the company? So, in Kellner versus Baxter, it was held that in a dispute between a promoter and another person, only the promoter is liable and not the company, which has not been incorporated yet. Because of the doctrine of privity, the dispute stays only between the promoter and another person, and this company is absolved of any liability. To retain liability of the acts, the acts which are done pre-incorporation, the company can novate the contracts entered into while during the stage of pre-incorporation. Now what this means is that all the old contracts may be substituted with new contracts with the company as the party to the contract instead of the promoters. The second type of liability is criminal liability. Can we attribute criminal liability to a company? Are the aspects of mens rea and everything satisfied? This was clarified in the case of Standard Chartered Bank versus Directorate of Enforcement. It was held in this case by the Apex Court that the company is liable to be prosecuted and punished for criminal offences. They rejected the notion that the company could avoid criminal prosecution in cases where a custodial sentence is mandatory. As the company cannot be sentenced to imprisonment, the court cannot impose that punishment. But when the imprisonment and fine are prescribed as punishment, the court can impose the punishment of fine, which could be enforced against the company. In another case, Iridium versus Motorola, The Supreme Court held that in all jurisdictions across the world which are governed by the rule of law, companies and corporate houses can no longer claim immunity from criminal prosecution on the ground that they are not capable of possessing mens rea. There are various doctrines on this point, like doctrines of willful blindness, collective blindness, alter ego identification, which govern this concept today and decide whether there was mens rea or not. So this is how criminal liability is decided. The third type is tortious liability. Liability under torts, which is applicable to individuals, is applicable to companies also in a similar manner. The companies do not get immunity from tortious liability. The principles of vicarious liability, strict liability, absolute liability are applicable to the companies as well. So this is it from my side. Now Kaustubh will continue.
Taking on from Devanshi, now I will continue with the next sections, that is from section 12 to section 22 of the Companies Act. As per section 12 of the Companies Act, a company within 30 days of its incorporation is required to have a registered office capable of receiving and acknowledging all communications and notices addressed to it and intimating the same to the registrar of companies within the said period, in order to make sure that the place of incorporation is not fictitious. This section also gives a detailed process for verifying the address of the registered office in subsection 2. Then in case of a one-person company, the words OPC have to be mentioned in brackets below the company's name. Now the next three sections are primarily based on the procedures for alteration of the company's memorandum, articles of association, etc. Section 13 lays down that the alteration in each of the clauses of the memorandum shall require approval of members by special resolution, and no alteration will have any effect unless it is registered with the registrar. When there is a change in the name of the company, the registrar issues a fresh certificate of incorporation. Any alteration of the memorandum relating to the place of the registered office from one state to another is effective only with the approval of the central government, and the company is required to provide a copy of the same application to the registrar. This clause further provides that if a company after having raised money from the public for one or more objects mentioned in its prospectus, if it still has some unutilized money, then it will not be able to change its object unless a special resolution is passed. For changing a name of the company, which is part of the memorandum of association of the company, written approval of the central government is also required. Now, moving on to section 14. This section allows a company to alter its article of association with its members by consent by special resolution. A company can alter its article by way of addition, deletion, modification, substitution, or in any other way, only if it wants. This alteration can have the effect of converting a private company into a public company, or a public company into a private company. If a company decides to alter its articles having the effect of converting a private company into a public company, or vice versa, it requires the approval of the tribunal. Normally, consent by members by special resolution for alteration of articles suffices. However, if the company's articles contains an entrenchment provision, that is, requiring consent of more or all members for alteration of article, the same shall be obtained. Now, section 15 says that every company has to compulsorily incorporate in every copy of the memorandum all article alterations which have been made or effected from time to time. If a company does not comply with this requirement under section 15, it is liable for a penalty of 1000 rupees for every copy of the MOA. Section 16 talks about rectification of name of company. Two circumstances are contemplated under this section, under which there could be a rectification of a company's name. The first being a company's name has a resemblance with an existing company, or if it is identical with the company's existing name. In such a case, the government may suo motu direct the company to change its name within 3 months from the date of receiving such directions. The second scenario is when the owner of a trademark can also make an application to the central government to the effect that the name of the company is identical with or resembles with the registered trademark, which is registered under the Trademarks Act 1999. If the government decides or determines that the submissions are true, it may direct the company to change its name, which it shall have to obey within 6 months. Now, moving on to section 17. This section states that when a company receives a request from a member, it should provide to him within 7 days from the receipt of the request and against payment of such fees as may be prescribed a copy of each of the following documents. First, a memorandum, second, the articles of association, and third, every copy of the agreement or resolution referred to in subsection 1 of section 117. If such agreement or resolution has been embodied in the memorandum or its articles, the company is obligated to supply the aforementioned documents, and if it fails to do the same, then then it shall be liable along with the concerned officers of the company to a penalty of 1,000 rupees each for each day of the default. Moving further, a company registered under one class of company under this act can convert itself into another class under the same act by making alterations in its memorandum and articles of association, and by complying with the procedure mentioned in section 18. Section 19 states that a subsidiary company is not allowed to hold shares in its holding company, and no holding company is allowed to allot its share to its subsidiary company. Either of the aforementioned acts done are held to be void. This has been done to maintain the separate operational identity of a holding company and its subsidiaries, and so that such an identity may be preserved. This section provides that a subsidiary company shall not acquire shares of its holding company, not even through a nominee, and if it acquires the same shall be void. However, if this section allows subsidiary company to continue to hold shares of its holding company if the same were acquired prior to it becoming a subsidiary of the holding company. Now, moving on, the mode in which documents may be served on the company, its members, and also on the registrar is provided in section 20. This section recognizes electronic transmission, which should be capable of being retrieved and reviewed, along with being capable of being printed legibly. A member of the company can also request the company to deliver documents through a particular mode for which he has to pay the prescribed fine. Now, moving on to the next section, section 21. This section provides for the authorization of a document or proceeding which may be signed by a director, the manager, a secretary, or any other authorized officer of the company. If any officer takes a decision without authority, such a decision would not be binding on the company. This section says that documents or proceedings require authentication by a company or contracts made by or on behalf of the company may be signed by any key managerial personnel or any officer of the company who are duly authorized by the board of the company in this regard. Coming to the last section for this topic, section 22. This section provides that a bill of exchange, hundi, or a promissory note which may be accepted, made, drawn, or endorsed in the name of the company or on behalf of the company by any person acting under its authority is binding on the company. The person so executing the bill of exchange, hundi, or promissory note may have authority of the company expressly. Where a company follows the aforesaid procedure, that is, it authorizes any person as its attorney in writing and under its common seal to execute deeds which are other than bills of exchange, hundi, or promissory note on its behalf, then execution of such deeds by such attorney and for and on behalf of the company shall bind the company and have the effect as if it were made under its common seal. That is all for this video, and now if you have any questions or queries regarding this topic that I discussed, then please contact us on our email or any members of the corporate law cell. Thank you.